We come from the same.
For Mr. Oraro SC. Ms. Nderu? Yes, Ms. Nderu is present, holding brief for Mr. Andrew Musangi for the second petitioner.
Who do brief for?
Mr. Andrew Musangi. There is holding brief for Dr. Nyawundi and Mr. Ochiel Dudley, D-U-D-L-E-Y.
Ochiel Dudley.
Yes, Ochiel Odwol. For Mr. Issa Mansour. And appearing together with Mrs. Sharon Minor, Mr. Samuel Batai, Ms. Fahima Jaffa, Ms. Wanja Wanjuki, and Mr. Michael Cheke. My Lord, if that appears like a long list, that's the JSC, so they need that number. For the first respondent,
The petitions which are pending,
yes,
starting with the one I referred for mention today in 89
yes.
for amendment. Was it served? Sorry?
May please go.
Yes.
Murugu for the is principally for the GSC. Mr. Nelson Harvey, President, who is here for the second interested party.
Yes.
Mr. Kiravu, who is present for the first interested party, and Mr. Peter, and none of them.
Maybe they can confirm. Those are for the respondents and the interested parties.
My Lord, on the part of the first respondent, I confirm we're not opposed to the application.
Your name?
This is a brief for Mr. Esa.
You don't oppose it, huh?
Except that we will be praying for strict timelines for filing of the amended
You'll
petition.
be seeking?
For strict and short timelines for
Yeah.
filing of the amended petition.
Next as well.
The petitioner is granted leave to file and serve an amended petition and shall do so by close of business 21st May 2025 and shall also file 5 hard copies with the court. Responses to be filed and served by close of business 28th May 2025. Rejoinder, if need be, to be filed and served by close of business 3rd June 2025. The mentioned date shall be confirmed after the other matters are called out.
Initial on that or clarification?
Just to clarify, seemingly then the application has been allowed.
Yes.
Yes. Yes.
In most of the matters,
Yes. In which files?
I believe, my Lord, maybe the parties can, I think that what we should do first is look at the consolidated petitions.
Yes.
That the council can inform the court what applications are pending.
We can start with the number 83 of 2025.
But perhaps, my Lord, before we get there,
Yes.
there were directions that were given
Yes.
following the empanelment that parties would submit hard copies of their pleadings to the court. So maybe we can begin with that first to see whether there's been compliance. And then now we can delve into the subsisting status of the petitions.
That was in the consolidated 5 files or in all of them?
In all of them.
In all of them.
Yes, so maybe we can begin with the consolidated petitions of the 5.
Yes, as
The
a
council
list.
can inform the court whether they comply.
Okay.
My Lord,
Yes.
James Chepkon,
Chief Corners.
appearing together with Alfonso Duan, holding brief for Mr. Raro, Senior Counsel. My lords, we are yet to comply. We haven't filed the physical copies of our petition.
These orders have already been here for a while. There is no need for us to hear the applications.
Yes.
We need to hear the petitions. So that what your lordship wants to do is to give us a time frame within which either to file submissions or prepare to come here for an oral hearing of these petitions. Otherwise, looking at the number of these advocates will be here until tomorrow.
I believe we would better utilize judicial time by skirting through and going to the main petitions. So perhaps the court will give us indications as to when to respond to the substantive petitions, the timelines for filing responses that will help us better utilize judicial time. Thank you.
On the part of the first respondent, we concur with the proposal made by Mr. Harvey.
Yes.
The first respondent has filed responses with regard to the applications and the petitions already.
Yes.
And so, my lord, I think in view of the fact that there is already subsisting conservatory orders, we should fast track the hearing of these matters, move to hearing of the petitions, so that if any party has not filed a response, and because there is already conservatory orders, then we can file their responses and we take directions for submissions and dispose of these matters with finality, rather than first hearing the application and then the petition.
To the petitions, that is the issue you are dealing with.
Yes.
Yes.
My lord, my name is Okach.
Got yes.
For the 16th and 18th interested parties. I'm also holding brief for Mr. Nyamodi for the 20th and 21st interested parties in the 5 consolidated petitions. My lords, what has been echoed by my learned colleagues earlier is exactly our position.
Yes.
And it is a fact that all these petitions were accompanied by certificates of urgencies, indicating that even the petitioners themselves appreciated the urgency. And I think the urgency was not just to obtain interim orders, but for the substantive issues raised before this court to be canvassed and dealt with. These are petitions, and it goes without saying, that have attracted great public interest, and the sooner we dispense with it, the better. Again, we see the resource of the court. We have 3 judges, eminent judges before us, and it will be prudent use of judicial time for these petitions to be dealt with directly. And I think none other than the petitioners should be the ones urging these applications as opposed to the respondents. Thank you.
So you support to dispense with the applications
Yes.
and go into petition? Yes. Any other counsel with the want to address us on that issue?
My Lord, I think that those were the respondents and the interested parties. Speaking for ourselves in petition number 86, we think that the court can dispense with the applications and remove the substantive petitions.
Any of the parties that is opposed to that direction that is being suggested by counsel, particularly from the side of the petitioners, the respondents, and the interested parties. So there is no opposition.
themselves even in
Yes, because you all just added the two
Yes, so we can have the two added to the
under
file,
the
which are
updated three.
consolidated. And then now we identify the parties in terms of petitioner one like that, and then the interested parties and the respondents.
Is it
That we can
agreeable?
meet away.
My Lord, I think my client will be the next file to be affected by that submission, which we have no position to. We agree that consolidation is this.
Any?
That you need to respond and do rejoinders.
Yes.
Then you retire and send us directions on the parties, so that the list of the parties comes from the court. Then it is sent via email. Then we adjust our meetings accordingly, instead of doing all that process here. We
You
just
don't-
agree on the timelines.
You oppose the consolidation?
So how then we proceed before even the responses have been filed?
Because even the petitioners might desire to put further responses
affidavits,
depending
yes.
on what is going to arise.
Yes, like in our case, we want to file a further affidavit. So given the directions that have been given in the responses to petition number 89,
Yes.
we think building on that,
Yes.
now parties can be directed to file their responses. The ones that want to file further affidavits can file, and then now we can come for a mention to confirm compliance.
Yes.
Yes.
If you can condition, I would for filing of responses, and then for the petitioners to file their further affidavits, it may be together with their submissions, and thereafter all other respondents and interested parties to file submissions in response. The court could give us a hearing date even at today's mention.
Rejoinders time also be added, so that when we come, we only agree on the issue of hearing of the petitions. Is that okay?
No, my Lord, it's not okay. I think we need to settle the issue now. Are we hearing the petition by submissions or oral evidence? So that we prepare in advance. Otherwise, we'll be in this litigation for 2 years.
Okay, but during the confirmation of compliance, that issue can be resolved very easily, because you address at that time after all have been put.
What is the problem settling it now?
Because we don't have the responses yet or the rejoinders, so we don't know whether this is a matter that will be heard best by submissions or by oral hearing.
No?
The difference-
Quite clear on the filing of responses and replies.
The difference between the last day of rejoinder and the mention date that we're giving you is 2 days. So we could give you those directions just 2 days after the last day for rejoinder, and then we have something that is comprehensive.
Very well, we'll go with that.
My Lord, with your kind permission,
Sorry?
with your kind permission, this is your catch.
Yes.
My Lord, even taking those directions, I think the main issue here is because of the nature of these petitions
Yeah.
and the number of advocates in this particular matter.
Yes.
By the time you are coming back, even on the date suggested by Justice Mwamuye,
Yes.
the issue is getting a convenient date, whichever way will be quite imperative, and especially for all of us. I
Okay.
think if we can consider, and especially because diaries are still moving,
Yes.
if a tentative date can be reserved, the issue will be getting that date which is convenient to everyone, and even to the 3 judges presiding over this matter. That will be the bigger issue, because by the time we get a convenient date, we will be late August by the time we come back. But it will be good to have some foresight, so that we reserve a date or 2 for this matter.
For the hearing,
Yes, yes. Just
even before the
whichever-
responses and rejoinders.
Whichever
Because the
way-
issue is, which has been raised by Advocate Harvey, is the mode of hearing, whether it is viva voce or we do it through affidavits and submissions. Which we are saying we reserve that issue of a hearing, mode of hearing, at the time of compliance, once we confirm all the compliance have been done.
I think that makes sense. We can then maybe take direction.
Because some might even feel that you not reply. With the time, yes.
Petition number E086 of 2025 and petition number E089 of 2025 shall be consolidated with the already consolidated petition number E083 of 2025 as they appear in the consolidated petitions, and send the list to the parties by close of business on 19th of May 2025. All the parties are required to submit their hard copies of their pleadings by close of business on 21st of May 2025. That is the pleadings that are already filed. Submit your hard copies by 21st of May 2025. Responses to be filed and served by close of business on 28th of May 2025. That is for those parties that have not filed responses yet. File your responses and serve them by close of business on 28th of May 2025. Rejoinders, if need be filed by 3rd of June 2025. The petitioner and all the parties supporting the consolidated petition to file submissions to the main petition by 10th of June 2025. The respondents and all the parties opposing the petition to file submissions by close of business on 17th of June 2025. Rebuttal submissions by the petitioners be filed and served by close of business on 24th of June 2025. All the pending applications are by consent of the parties dispensed with. Conservatory orders in place to remain in force until this petition is heard and determined. Further mention on the 4th of July to fix a date for highlighting of submissions.
Most of them. Most of them which are still pending in the proceedings. So perhaps we can take directions whether they will be subsumed in the new petition or they are being dropped, so that then we know which direction to take.
Because my brother Judge Bahati says that he dealt with them together with the application with in same ruling.
Yeah. We have Ms. Mulwa who is informing me that it is number 83.
No, my Lord, all the appeals were determined by Justice Bahati.
Yes.
It will be repetitive, have them outstanding.
Okay.
So let's just go on with the hearings.
So are they alive?
No, they're not live. All the issues were determined.
You can also deem them as to be applications which have been dispensed with.
No, they're determined.
Okay. So we now focus on petitions. Do your replies.
I was busy lunch in the party. when you start with the horses, we missed it. Yeah, so we go.
So, Mr. Agudo.
Your Lordship, perhaps to assist the court, there's a list going round.
Yes.
Where parties are required to indicate their emails. So perhaps my colleagues who have not done that will do that, so that we surrender it for purposes of assisting the court.
The list of?
There's a list where we are indicating our emails.
Yeah.
The court is supposed to send us directions.
Mm.
Thank you.
So, Your Lordship,
yeah.
There are also video housekeeping issues. Since the matters have been consolidated, would it be wise if...
Sorry?
The documents that have been filed.
Yeah.
Apology, just in terms of housekeeping issues.
Yes.
Number 86 and 89 have just been consolidated.
Yeah.
Would it be wise then if all the parties serve each other with all the filed documents in terms of responses, so that at least everybody can...
All the parties they do it, sorry. All the parties they?
If they can serve each other and exchange their filed documents.
Council, what is your name?
I'm appearing in number 89.
I think that is quite in order. That suggestion is in order. That all the parties should now serve each other with their some clear periods, so that at least we all know which party is saying what, so that at the end of the day everybody is aware of what is going on in all the matters. But I think the list that is circulating will be helpful, because that is what will assist now the parties now to be able to serve all of you. So once that list is generated, we will ask the DR to share it with all the councils in the matter, so that we can serve each other.
And on the housekeeping issue, with regard to the hard copy pleadings, do parties now give a set for each of the judges of the bench, or does one set suffice?
That we gave in 89 for 5 hard copies. Please, when you're filing your hard copies, we need 5.
Any other issue?
Yes.
For mention.